Welcome to episode 17 of the Legal Scoop, our webinar series here at LOMAD, where we talk about recent wins that our attorneys or our staff had at the firm. I'm Brendan Shannon. I'm an associate here at the law office of Melissa Day, and I'm joined today by my colleague David Clayton, who's going to talk about a recent win that he had involving the Fox v. Altmar Parish decision. So I'm excited to hear about that. Why don't you say hello, David?
Hello, happy to be here.
Thank you for joining us today. And for those of you who don't know, David is actually our newest attorney here at LOMAD, and he's already winning. So we're very pleased to have him on the show today, and we're excited to hear about this case. So to start off, if you could just give us the basic, bullet point background details of this claim.
Sure, thank you. The claimant in 2014 experienced a right shoulder sprain at work, allegedly, and she went for treatment where the doctor noted initially that she had pre-existing rheumatoid arthritis. She saw this doctor one additional time about a month later, where he noted that she had unrelated foot surgery and was scheduled for another surgery, but that her right shoulder prognosis was good and that she was already improving, and that she would only return if she needed further treatment, which she did not return to that doctor, and there was an 8-year gap in treatment until her shoulder bothered her again in about 2022, where the doctor she saw that she had osteoarthritis, referred her for a surgical evaluation, and these doctors were aware that there was a 2014 work-related injury, but they did not look at her actual relevant medical records and didn't link anything substantially to that injury. They were just linking that the injury happened.
So basically they stated that there was a prior accident, we're aware of it, but they weren't really, looking at the prior imaging that showed the rheumatoid arthritis or, any reports from 2014, correct?
That's correct.
Okay, and then she ultimately did undergo surgery, right?
Yes.
Okay, and injections and extensive treatment, a fair amount of bills were racked up.
Yes, tens of thousands of dollars in medical bills.
Okay, so for our viewers, this brings up a pretty interesting issue, and one that we like to use a lot, which is the case in Fox v. Altmar Parish, which is sort of a paraphrasing of the title because it's got a long title. It's a third department case from a couple years ago that states that a doctor who's issuing an opinion on causal relationship, whether it be causally related treatment or that a claim for an actual injury site should be established because it's causally related, that doctor needs to review prior relevant treatment records. It makes sense. So if a claimant had extensive prior treatment to the site that they're claiming, 5 years prior, the doctor needs to not only be aware of that, but actually to review those records to be able to make an informed decision within a reasonable degree of medical certainty on the issue of causal relationship. So, David, it sounds like here you were able to argue that because while these doctors were aware of this prior accident, they did not actually review these records and they were not able to make a sufficient opinion on causal relationship. Is that accurate?
That is. We also obtained an independent medical exam that concluded that it was a minor 2014 sprain, that there was no real evidence that these conditions were linked for the need for a total shoulder replacement nearly 10 years later. The IME doctor found that degenerative conditions experienced by the claimant were common in over 90% of similar cases where rheumatoid arthritis existed over a 5-year period, and due to the claimant's advanced age, he concluded there was no causal relation between the 2014 injury and the need for surgery in 2023.
Right, and then correct me if I'm wrong, but the key here was that the IME doctor who did the record review reviewed all the prior records from 2014, right?
That's absolutely correct.
So then you have two things there. You have Fox v. Altmar Parish, where you can say the treating doctor should be discredited for not reviewing these prior treatment records, and our doctor should be credited over the treating doctor because this doctor did review the prior treatment records, and really it's the only valid opinion on causal relationship. That's a great win, David, and a very impressive win for your first win, so I appreciate you coming on here to talk about that with us today. For anyone watching, I hope this has been informative. Again, if you have a claimant who has prior injuries or even like rumors of prior injuries to overlapping sites that are being claimed, get an ISO report, and then consider obtaining those prior records, because you could have a very strong argument against causal relationship or causally related treatment, as we did in this case where, like you said, David, you got up to $50,000 in medical bills found for the carrier. So thank you for coming on today.
Thank you very much.
If you would like to see more of these videos, please subscribe below. You can also go to our website and become a LOMAD VIP, where you'll get notifications and access to all of our content. We've got other video series as well as a newsletter that I'm sure you would like to take a look at. So thank you, and we'll see you next month.